Remember I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all. And the evidence will show that my son said my dad shot my mom. It's the correct statement if you want to cite statements, if he even said it.
That's Ronnie Oneal. He's on trial right now, death penalty case, accused of murdering his girlfriend and his daughter, and also stabbing his son. That's his opening statement. It was unlike any opening statement we've ever seen here on Court TV. But he's continuing to represent himself inside the courtroom, everything at stake. So his 11-year-old son is an important witness, perhaps the star witness for the prosecution, had to testify. And of course, if he's representing himself, he does the cross-examination. Our great affiliate, WFTS down in Tampa, has the story tonight.
Do you remember the night when something bad happened to your mother and your sister?
Yes.
State Attorney Ron Gale wasted little time getting into details with Ronnie Oneal III's son about what happened to his mother and sister in 2018. He was just 8 years old at the time.
Basically, I was sitting in my room and I saw my mom and my dad arguing.
He went to the back bedroom and saw his dad holding a shotgun, he told the state. Shortly after that, he saw his mom run into his sister's closet and hide. He was in the living room when he recalls Oneal telling him to come in and help him kill his mother.
I went in the room and then he handed me the shotgun and helped me shoot it.
But he can't remember if the gun went off while he was holding it. He told the state he saw his dad kill his sister, and then he says Oneal III came after him.
I was laying on my stomach, he had his foot on top of me, and he was holding me down.
He says his dad attempted to light him on fire, but can't remember much more after that, besides walking out of the garage.
And I just remember going to someone and saying that my dad killed my mom, and then I got a mask put on me, and then I don't remember anything from there.
Oneal III was eventually able to cross-examine his son.
It's good to see you.
On several occasions, Oneal questioned his son on details.
Did you see me beat your mom?
No.
Did you see me shoot your mom?
No.
Which he seemed to be using as a way to prove it wasn't matching up with what the boy said previously to detectives and attorneys in 2018.
And she asked you who was getting the shooting, and you said your mom. And she said, okay, did you see it? And you said, I heard it and saw it. Do you remember saying that to her?
No, I do not.
Judge Michelle Sisko noting on the record,
Mr. Oneal appeared to be in command of the facts and knew the points that he was trying to get across, and I feel that he did so competently.
Unbelievable. I mean, unbelievable what's taking place inside that courtroom. Still with us, the state attorney for Palm Beach County, Florida, Dave Arenberg, is with us. Dave, some people are wondering, why does our system allow this on two levels? One, someone who, he's not a lawyer. At one point, he was not competent. He's got mental issues, obviously. And then the other part, that poor 11-year-old boy has to sit there and answer questions from his father.
Vinny, the Supreme Court has held that an individual has a constitutional right to defend himself. They've got to go through what's called a Feretta hearing, where they've got to prove to a court that they are competent, they understand, and they have a level of education where they could be their own lawyer. But of course, you learn early on in law school that a lawyer who represents himself has a fool for a client. And as far as his son, he was able to testify via closed circuit. He was in a different place. It was on TV. So he didn't have to actually be in the same room with this guy. And he also was allowed to have a golden retriever with him, which was helpful, I guess, as a therapy dog. But, you have a Sixth Amendment right under the Constitution to confront your accuser. And it is notable that the Constitution says a lot about defendants and suspects' rights. It says zero about victims' rights. That's why many states pass their own amendments to their state constitutions, like Marcy's Law, to protect victims. But this is a lesson in constitutional law which bends over backwards to protect the defendant, the suspect.
Okay, the other big part of this case is, if in fact he's convicted, we don't want to put this 11-year-old boy through this again. We don't want to put the family of the victims through this again. Are there landmines as you are trying a case against a defendant who is representing himself, whether you're a prosecutor or you are the judge on the bench? How do you make sure that this thing won't come back and won't get overturned because of some issue related to the fact that this man is representing himself?
Yeah, it's tough because he's apparently had some mental issues that will come into play on appeal. You know that on appeal, the public defender's office will try to use his mental state, saying that he was not able and the judge should not have allowed him to represent himself. Usually, at least in all the cases I've seen, the judge will require a public defender or a defense lawyer to sit there as like a co-counsel. They don't really do much, but they're there just in case, and they can provide advice to the client. But you are worried about that. You don't want this case to have to be done again. That's why the judge made that statement saying, I find that he knew what he was talking about, that his questions showed that he understood the process, that he had a knowledge about the law. She's going to do that throughout the trial just to put in the record that he is competent to prevent this case from being overturned on appeal.
And the prosecutors, I mean, their hands are tied, right? Because you're saying it's the Supreme Court, it's the Constitution, it's all these things that are much bigger than like a prosecutor can't say, listen, judge, we just don't feel like this is fair, right? This isn't fair. We want a fair trial here. That's not part of the equation here. It's not, because he is demanding to represent himself.
Right. And Vinny, you know that when you're prosecuting a case, you don't want to have to face a pro se defendant. You don't want to have to face a guy like this, because it turns the trial into a circus. And it can be overturned on appeal depending on how crazy he is. And obviously, you don't commit this kind of heinous crime without having a little bit of crazy in you. It's just that whether you're crazy under the law, whether you're legally insane, which he's not, because that's a different definition. You have to believe what you did was not wrong. And he obviously thought he was doing what he did was wrong, because he's trying to evade it. He's trying to exculpate himself out of this, saying that this was self-defense. So then it's a question of whether he's competent to stand trial and to be his own lawyer. And the judge has found, yes, he is, and yes, he is. But ultimately, the prosecutors and the victims' families will hold their breath, hoping that this case is not ultimately overturned, so they don't have to do this whole thing again.
All right, we will continue to follow what's happening down there. Really appreciate your insight tonight. Dave Arenberg, the state attorney for Palm Beach County. Thank you, sir.
Thanks for having me, Vinny.